ratified the treaty by 2/3 vote. Question: may a petition for certiorari be entertained by the Supreme Court to annul the treaty? And number 3, will a petition for certiorari to annul the treaty prosper? So those are the 3 questions, and this is a problem, sample bar questions given by the Supreme Court together with the coverage of the bar exams. Now the advantage now is you will narrow down your pre-week review to the syllabus on the coverage of the exam. Now, my short answer to this are this, because at that time, when this was released by the Supreme Court together with the syllabus of the coverage, the questions were there were many questions. So I gave a very short answer. No, because ratification of the treaty is a political question outside the judicial power of the Supreme Court. It relates to the conduct of foreign relations, to which the President is answerable only to the people. A political question is beyond the power of judicial review of the Supreme Court. And then Pimentel versus Executive Secretary. In answer to number 2, whether the petition for certiorari to annul the treaty will prosper, I answer yes. The petition for certiorari to annul the treaty will prosper because the foreign investment in prepared shares up to 40% of is allowed by the Constitution, as held in the Wilson versus Gamboa case. As to voting rights, meaning prepared shares, the limitation on 60% on the prepared shares is absolute. While the 1987 Constitution does not distinguish between common shares of stock authorized to vote and preferred non-voting shares, the Supreme Court held in the leading case of Gamboa versus Tebes, in the resolution of the motion for reconsideration, that the percentage limitation of the foreign investment must be computed separately on both the common shares and the preferred shares. Now, I have a note here. The first decision of the Supreme Court in Gamboa versus Tebes held that 40% limit of foreign investment must be computed on the preferred voting shares. On reconsideration, the Supreme Court held that the 40% limitation of foreign investments must be computed on both the common shares and the preferred shares. Now, why do I know this? I read the decision, I studied the decision because I was involved in my research legal services in the drafting of the second motion for reconsideration. So the final resolution on the issue was tackled in the motion for reconsideration. Whereas in the first in the first decision on the case in Wilson Gamboa versus Tebes, the 60-40 must be computed only on the common shares. The clarificatory resolution on the MR is that it must be computed both on the preferred and both on the voting shares and the preferred shares. Now, relating that to ABS-CBN. Under the Constitution, the business of media is limited to 100% Filipino capital. Now, we have discussed this already, that ABS-CBN is funded by foreign investments in the guise of Philippine Deposit Insurance Corporation being issued by a subsidiary, which are entitled to dividends based on the business operations of ABS-CBN. So, what cannot be done directly, cannot be done indirectly, is a legal proposition founded on equity. I even say in my petition for intervention in the Supreme Court, giving or trying to contribute to the clarification of the issue, I say, when it quacks, it must be a duck. In political law, you should know what are the inherent powers of the state. That is very basic. The police power, which means the power to legislate for the good and welfare of the public. The police power is wielded by the legislature. Carlos Super Drug Corporation versus DSWD, GR number 166494, June 29, 2007. Eminent domain. Well, this is the power of the government to take private property for public use. No private property may be taken for public use without payment of just compensation and without due process. In my hometown in San Jose, Batangas, where the government started wrecking properties, stores near the marketplace, including properties that are covered by tax declaration, meaning privately owned property. I asked for a meeting with the local government code and with the local government, advising them that they cannot take the law into their own hands, and private property might not be taken even for public use without just compensation and without expropriation. So that is the power of eminent domain, that it must be for public purpose with the least damage to private property and with prior compensation. Now, to the credit of the local government of San Jose, Batangas, they respect property rights, and I just tell them, if this is the policy of the government, let them file the expropriation case, because many similar move in the efforts of local government units to appease or to be in good grace of the national government. They started wrecking private properties like demolition, road widening without just compensation. And Isko Moreno was vigilant enough to stop this in Manila. And to the credit also of the local government of Calamba, when the restaurant of a friend was about to be wrecked because the Department of Public Highway wanted to use it. Of course, I am not discouraging the use of private property for public purpose, but that can be done under the Bill of Rights by respecting the right to due process and the right not to be deprived of property without due process of law. And that is the essence of eminent domain, the power of government to take private property for public use upon prior payment of just compensation with the least injury or damage to private property. And one important consideration here when this is asked in the bar is when is the time of reckoning for the fixing of just compensation? It is at the time of taking. But as you see, sometimes even the government, wittingly or unwittingly, would not make prior payment before taking private property. And that is definitely a violation of the Constitution, that no private property shall be taken for public use without prior payment of just compensation. And usually it happens, and it has happened in my properties in Nasugbu, Batangas, where several hectares of my property were taken for public use, and until now I have not been paid. So the issue is when private property is taken and payment comes later, what is the reckoning value of the property? The simple answer is at the time of taking. And then the government must pay interest if the payment is delayed or not made at the time of payment. And on this, I would like to cross to commercial law. Now, the general principle in civil law on interest is that no interest is due unless it is fixed by law or it is stipulated in writing. Even if the rate of interest is stipulated in writing, where the rate of interest is potestative, it is subject to fluctuation at the whims and caprices of the bank without the written consent of the borrower. The floating rate of interest is null and void for being potestative, being dependent upon the will of one of the contracting parties, which violates the essential equality and parity of rights between the contracting parties. One principle in contract is equality of rights. We will go to that when we tackle obligations and contracts in civil law. I am just reminding everyone that the rate of interest now, starting July 1, 2012, is 6% per annum as fixed by the Supreme Court. No, not the Supreme Court, by the Bangko Sentral ng Pilipinas. And you may be wondering, so am I. How come that the central bank amended the usury law on the fixed interest rate without an amendment from Congress? And it is a source of great wonder to me, because implementation by regulation can only give life and spirit to the legislative intent and might not replace or amend an act of Congress. But that is how it goes. And the Supreme Court, in the case of Bayani Andal versus PNB, affirmed and confirmed the power of the Monetary Board to fix the interest ceiling. And with respect to legal rate, it is now 6%. And the legal rate is applicable where there is an agreement to pay interest, but the rate is not stipulated, or the stipulated rate of interest, as in case of potestative floating rate of interest. The applicable legal rate of interest is 6%. Now, while I am on it, I might as well complete the rule where an extrajudicial foreclosure sale is made by the sheriff, and the bank is the creditor. To my mind, there is a violation of equal protection of the law, because under Section 47, now I repeat, Section 47, the first time I discussed this, I mentioned 43, but nobody pointed out the mistake that I made. It's Section 47. The redemption period where the lender is a bank is within which comes first registration of the certificate of sale by the sheriff, or 30 days from the date of the auction sale. That is under Section 47 of the General Banking Act of year 2000. Now, under Act 3135, which governs extrajudicial foreclosure, where the lender or the mortgagee is not a bank, the redemption period is 1 year from the registration of the sheriff's certificate of sale with the Register of Deeds. And in fact, that is what is included in the manual issued by the Supreme Court for the guidance of the sheriffs. Now, can you not declare Section 47 null and void for being discriminatory and violative of equal protection of the law, where I do not see any actual substantive distinction that should make a difference in the treatment in favor of the bank? Now, the third power is taxation, and the usual question is, how do you distinguish taxation from the police power? So I'm citing here the case of Giroche versus Department of Energy, GR number 159796, July 17, 2007. The purpose of taxation is to generate revenues to fund the operations of government. The purpose of regulation in taxation is only incidental. It is an exercise of the police power if regulation is the main purpose and revenue is merely incidental. Now, let us come to the issue of online sabong. Extraordinary situation calls for extraordinary remedy. If this is the way to raise revenue to fund the fight against COVID-19, so be it. Nobody can question that. And if the people acquiesce to the revenue raising exercise being conducted by the government through PAGCOR, so be it, because what is important is to save precious human life. technically, under the law, the distinction between regulatory police power and taxation is that taxation is the power vested in Congress to raise revenue in order to finance the operations of government. On the other hand, police power, or rather the power of regulation, which is based on the police power of the state, must be limited in the license fee to reasonable and necessary expenses for regulation. So what is the nature of the 75 million initial deposit required by PAGCOR, and the fees being collected by PAGCOR to 12,500 per fight, which PAGCOR has a minimum requirement of at least 200 fights a day. That's every day. Because PAGCOR, whether you meet the 200 mark or not, will collect 12,500 pesos per fight. So to be viable, an online operator must be able to put up in our computation at least 250 to be not to lose or break even and make a little money. 250 fights a day. Can you imagine how many fights that would be in a day? So online operators should manage the derby well enough so that they can do it every day of the week, 24 hours continuous fight to be profitable because of the imposition, very high imposition being collected by PAGCOR. Now, the young new operators are at a disadvantage because under the present circumstances, it would be very difficult to be fielding at least 250 fights a day. It requires disciplined management. And in my view, this is feasible only if there is a cooperative effort with the online operator by hackers who build derbies in cockpit operation. Because without the cooperation of members, it would be very difficult to be fielding 250 fights a day continuously every day of the week, the month and the year. And the capital, the operating capital, is very expensive for newcomers because if they have not been earning money in online operators, the capital is very big. I made a computation, minimum of more or less 300 million a month. And if that is not matched by generated income or revenues, which must to break even or be profitable, must have bets left and right of at least 600,000 per fight. Anyway, I am very glad that the NCA is now operational. And in fact, I sent an entry just today, 8 stag 1 day for a friend. So this is a good development for Kakers who may wish to join derbies now. And I predict that sooner than later, if online operators continue, that we can field in big-time derbies free of pot money. And in fact, we are even paid now. Today, I am given an allowance of 10,000 for 8 cacks and per win, 10,000 per win. So that's good because my only desire is to win championship again, if I can, as a passion. Now, I have decided to decline the presidency of the World Slashers Alliance, a new upcoming online operator, because I believe that I will be more effective. As a friend of small Kakers and breeders, if I remain neutral, and anyway, my only desire is to play the game with my roosters, and by being neutral, I will keep my loyalty to my longtime friend, Patrick Antonio, and I will not be clashing with a longtime friend, Atong Ang, because it is my desire to unite all the big players in the industry for the common benefit of the sabong industry, big or small. And we are now opening our cockpit in San Jose, Batangas. And we say that cockfighting is a game of common men and kings with million thrills. So, distinction between taxation and the police power, because the exigency of the service is a equitable ground to tone down or even alter final and executory judgment of a court of law based on the principle in equity that supervening circumstances may justify an alteration or departure. And I repeat what I said last time. In international law, where there are changed facts and circumstances that render the execution of an international treaty oppressive, inequitous, then the negating party is justified in refusing to execute the treaty under the principle, and please remember this, rebus sic stantibus. That is a well-known principle in international law, that a treaty obligation may be sidelined and ignored if there are changed facts and circumstances that would render the rendition or compliance with the treaty obligation inequitous, unfair, and unjust. And that is also a principle which may be used in the execution of a judgment that might have been rendered unjust, unfair, and iniquitous, which may be altered under the principle of supervening event doctrine. Now, before we leave the power of taxation, just remember the distinction between the regulatory police power, where the license fee must be limited to reasonable cost of regulation, compared to taxation, whose purpose is to generate revenues to fund the operations of government. But again, there is an exception under the principle of exigency of the situation. And I developed this theory when Gloria Macapagal Arroyo declared a state of rebellion. So, arrest left and right, searches and seizures left and right were done during the state of rebellion. And it does not follow the protocols or the requirements of warrantless arrest, searches, and seizure. But the Supreme Court justified the warrantless arrest, searches, and seizure under the exigency of the situation. And there is a decided case, which I added among the grounds for warrantless arrests and seizures in my handouts. Let's go to another topic. When I took the bar in 1970, entering the examination room at UE, I was loudly talking. Question number 1, what are the modes of amending the Constitution? True enough, question number 1 was that. Because I was very fond in my study for the bar, and while I was a student in UP College of Law, I anticipated the questions that might be asked. And I anticipated that because that was 1970, and 1971 was the convening of Constitutional Convention to amend the Constitution. So, I'm advising everyone, please master the provisions of the Constitution on amendments and revision, and what are the requirements. I will not go into that because I have only 3 hours until 12 o'clock to finish public international law and political law. And I can very well do that because I used to be a lecturer, one-man lecturer in the pre-bar of the global best practice when I was the only lecturer for the day for pre-week. So, in the morning from 9 to 12, the morning bar exam, for example, political law and public international law on the first day, and labor in the afternoon. And so, I was conducting that until I was dismissed by the global best practice and was never allowed, despite my apologies. Because one afternoon, while I was supposed to go back, I was the guest of honor in 2016 because I won the International Derby in Araneta Coliseum, and I was the guest of honor in an afternoon with Kakers. And I was very elated to be in the party given to me. I was not able to go back to lecture in the afternoon, and the global best practice was so pissed off, they never allowed me to lecture again. It is the same group that would sponsor seminars. One-day seminar in Manila Pen, where I am the only lecturer from 8 to 5. And they charge 2,500 for at least 100 participants. So, very easily, that's more than $1 million they earn, and they just pay me 35,000 per hearing session, where I was the lecturer the whole day. But I'm all right, because when I was a new graduate, making handouts and going rounds among the bar review centers, I was not yet taken in, because I just passed the bar, but I printed my handouts, and I was distributing them among the bar law reviews centers. And I was, when there was no lecturer, I would come in and gave my lecture the way I have been giving lecture. And in 1972, while I was doing that in the UP Law Center, my car was carnapped. That was in 1972, immediately before the declaration of martial law. Together with all the handouts that I was selling, because I was not born rich. So all my review materials that I was distributing at that time at nominal cost, 5 pesos per copy, just to cover the Xerox expenses, were all taken with my car that was carnapped while I was doing volunteer bar review at the UP Law Center. That was in 1972. I graduated in 1970. I published my digest of cases, important cases, and my answer to the 1970 bar. And also, I asked the bar top-notcher, who is my friend, in the 1971 bar examination, which I also published together with my handouts. Now, so they thought that I had a leakage. Why would I be able to know what would be the questions? And my grand uncle at that time was a sitting justice of the Supreme Court, cousin of my mother, Justice Kerubi Makalintal. So they were suspecting that I had a leakage, but far from the truth, because I pride myself as a descendant of honest and straight jurists and magistrates. And I'm referring to Justice Roman Usaita, who out of delicadeza resigned as Justice of the Supreme Court when he was bypassed, and Justice Ricardo Paras, who was his junior, was appointed Chief Justice. Now, delicadeza nowadays is a very rare commodity. And then, Chief Justice Kerubi Makalintal has a name that has never been tainted by any whip of graft and corruption, even as he served as Justice and Chief Justice of the Supreme Court, and even Speaker in the unicameral Batasan Pambansa during the time of Marcos. So it is not true that he gave me the questions, because he was as straight as an arrow, and he was very honest. So, what are the modes of amending the Constitution? Constitutional Assembly. Congress by a vote of 3/4 of all its members. Now, of all its members is susceptible of interpretation. Is it the members of the Senate, who are only 24, with the House of Representatives, who are more than 200, including the party list, or in a joint session assembled also, but voting separately? So that is an issue that is still open now. But if you will see the legislative history, the intention really is each house voting separately, because it is highly anomalous. If the 24 Senate members would be voting in a joint session assembled numerically per capita, and the legislative intention, the verba legis versus anima legis. The anima legis is found in the other section of the of the Constitution, which provides that Congress, the President may declare war with the concurrence of 3/4 of all the members of Congress, each house voting separately. So, do you see the legislative intention? It cannot be in a joint session assembled, each member of the Senate and the House voting per capita individually. That is anomalous, unthinkable, and uncalled for, and runs counter to the principle of statutory construction of anima legis versus verba legis. Now, if the Constituent Assembly or the Constitutional Convention would submit for ratification of the people in a referendum, so it must be a general election. However, in the Habiliana cases, the 1971 Marcos Constitution that was drafted by the Marcos Constitutional Convention, we still recall the expose of Quintero, that they were bribed, and so everybody calls it the Marcos Constitution. And the way it was ratified was by barangay acclamation. And so the barangay captain would ask, are you in favor of ratification of the Constitution, 73 Constitution? And the report of the barangay, and this was during martial law, was that it was approved by acclamation. And no less than the majority, slim majority of the Supreme Court in the Habiliana cases affirmed the ratification under the principle that the voice of the people is the voice of God. So the people acquiesce or approve the Marcos Constitution. And in the Habiliana cases, by a slim majority, the Supreme Court held that there is no more obstacle to the 1973 Constitution being considered valid and effective. Now, the new Constitution has a third mode, which is called People Initiative. So, what is the meaning of People Initiative? By petition of at least 12% of the registered voters and 3% of registered voters in each legislative district, amendments or revisions may be proposed by the people. But then, the Supreme Court held that the questions in People's Initiative must be presented to the people. And because during the time of Fidel Ramos, when a petition was filed, the Supreme Court held the petition to amend the Constitution by People's Initiative was declared null and void because the very questions or provisions for amendments and revisions were not presented to the people by the lawyer who was the lawyer for President Marcos and then my co-lawyer during the Macapagal administration, then the lawyer of the father of Grace Po, and then later I think he is also a lawyer of the present administration. Then distinguish amendment from revision of the Constitution. Amendment, minor revision. For example, there was an attempt to amend the economic provisions by opening up ownership of land and real estate to foreigner. So it is only an alteration of minor change in specific provisions. Now, revision, if you change the entire structure, like shifting to federal form of government, shifting to parliamentary form of government, you need a revision of the Constitution. And that is by judicial pronouncement of the Supreme Court. So here, one question that I posed, the answer is self-explanatory. Might the Constitution be revised by shifting from the presidential to the parliamentary form of government through initiative and referendum? The answer is no. Revision is possible only through constitutional assembly or constitutional convention, not through initiative and referendum, which is a mode allowed only for amendment of the Constitution, meaning minor revision in the People's Initiative. Now, shifting to public international law. This has been asked time and again, and that's why I put it every year in my predicted question in the bar. What is the principle of jus cogens in international law, which constitutes a limitation on the power of the Constituent Assembly to propose change in the Constitution? Answer. Jus cogens or peremptory norm of international law means a norm accepted and recognized by international community of states as a whole, as a norm from which no derogation is permitted, and which can be modified only by a subsequent norm of general international law having the same character. Citation, Article 53, Vienna Convention on Treaties. Now, before I forget, this is the same treaty that governs the withdrawal of a sovereign state from a treaty. And while we are at it, let us now discuss the withdrawal by the President, number one, from the International Criminal Court, created by the Rome Statute, a multilateral treaty creating the International Criminal Court, vested with universal jurisdiction on extrajudicial killing, abuses of heads of government and agents of government, genocide, and violation of international humanitarian law, like engagement in war and other protocols in areas of conflict. There is a pending case in the Supreme Court, and this might be asked because when the question of executive privilege was involved and not resolved yet by the Supreme Court in the Neri case, and in the case of Randy David versus Executive Secretary, those cases were still pending in the Supreme Court on executive privilege and the right of Congress for oversight and the right to investigate the executive department. The distinction between investigation in aid of legislation and oversight investigation known as question hours. And this was before the decision of the Supreme Court was released or promulgated in David versus Ermita. This was taken in the bar. So we will discuss this in relation to what Richard Gordon is doing. Going back to the withdrawal by the President, one, from the International Criminal Court under the Rome Statute, and number two, from the executive agreement with the United States on visiting forces, which anyway, the President has suspended the withdrawal in the light of the emergent contingency that we might call on the United States if we are attacked by China on the South China Sea. Under the Vienna Convention, first, before I go to that, if you will read carefully the provisions of the Constitution, the requirement of 3/4 of the concurrence of all the members of the Senate is applicable not only in treaty but also in international agreement. Please take a look at that provision. Because the old distinction between an executive agreement, which is temporary in nature, which the President may enter into without the concurrence of the Senate, and a treaty which requires two-thirds vote of concurrence by the Senate, there is no more distinction because both an executive agreement, international agreement with foreign countries, and a treaty, there is no more distinction between an international agreement and a treaty. Both require the concurrence of two-thirds of the Senate. And now, let me crisscross to international law. The dispute between China and the Philippines in the South China Sea. Under the international law on the UNCLOS, that is an international treaty on the law on the sea, under the United Nations, UNCLOS. United Nations Covenants on the Law of the Sea. There is no question that 2 nautical miles zone from our baseline is our exclusive economic right, where the Philippines has the entitlement to the exploitation, development, and utilization of the natural resources on the seabed. And the dispute, I repeat, again, because I think I mentioned this in passing also in my previous presentation, but while we are at international law, let me repeat it once more for emphasis so you will remember. The issue is whether a joint venture agreement between the Philippines and China for the exploitation of our economic zone, where it is anticipated that there are oil resources beneath, and there is a joint venture agreement entered into by Manny Pangilinan on behalf of the Philippine government, and I suppose with the imprimatur of the then Gloria Macapagal Arroyo with China. I would not say my good friend, Tony Carpio, former Justice of the Supreme Court, said that only a Filipino natural citizen may exploit, explore, develop, and utilize resources under our sovereign economic rights, economic zone measured 220 not 220, 20 square nautical miles from our baseline, he said. That is his reading, because that is the literal verba lehis interpretation, because the Constitution uses Filipino, and he considered that as natural Filipino. Now, who is a Filipino entitled to own land and to exploit natural resources? Who is authorized to engage in transportation, partially nationalized, 60/40. Under the Foreign Investment Act, a 60/40 corporation organized in the Philippines, that is with 60% voting shares owned by Filipino, is at par and has equal right to explore, develop, and utilize our natural resources like mining. And in the case of the Bugal decision of the Supreme Court, where financial, technical agreements are involved, foreigners may even enter 100% with 100% capital in mining, where there is a technical and financial agreement involved. in recognition of by the Supreme Court of the lack of Filipino capital. But again, this is a gloss legislative exercise by the Supreme Court, to my mind, amending the provision of the Constitution. Because before the motion for reconsideration, the decision is that the 60-40 requirement, that only 60% of the authorized voting capital stock might be shared, must be controlled by the Filipinos, and only 40% preferred non-voting shares would be allowed to foreigners. And that is reiterated in the case of Gamboa versus Tebes. But the law is what the Supreme Court says it is. Because after the Supreme Court, there is no more appeal. And if you appeal to God, and you are a practicing lawyer, you will be suspended for life. Like what happened to my co-professor in Ateneo when he was representing Erap Estrada. He lost a case in the Supreme Court. He made an appeal to God and gave a copy to the Supreme Court. He was suspended for life. Now, during the time that Rene Corona was the Chief Justice, who was an Ateneo graduate, he was encouraging, or some friends are encouraging, my co-professor to just apologize to the court, and his license to practice law, including the right to teach, would be reinstated. But he refused. He did not apologize. He did not ask for reconsideration. So my friend Alan Pagilla, I do not know where he is and what he is doing now. But since his suspension from the practice of law is indefinite, he cannot even teach law until now. And he was a good fellow, a very industrious fellow. He was teaching in addition to Ateneo Law School in schools in Batangas City. That's why I know him. Going back to the case in the Senate, I think we have discussed this. Under the Vienna Convention on Treaties, it is the authority that can ratify a treaty, who can withdraw a treaty to take effect 1 year from the notice of withdrawal. Our President sent a notice of withdrawal to the ICC pursuant to the Vienna Convention on the Law on Treaty. And after 1 year, the ICC recognized that we are no longer under the jurisdiction of the International Criminal Court. Now, there is a principle in remedial law that jurisdiction, once acquired, shall continue until the final termination of the case, which has no application in the case against the President, because at the time of the termination, the ICC has not acquired jurisdiction over the President. So that applies only the rule that once acquired, jurisdiction continues, would have an application where the court has earlier acquired jurisdiction over the case. Now, on what to answer. That is predicting the outcome of the cases filed by members of the Senate to declare null and void the withdrawal from the ICC and the withdrawal from the Visiting Forces Agreement. In the United States, where we copied our Constitution, the U.S. Supreme Court, when President Carter withdrew from the treaty with Taiwan, the Supreme Court declined to review the withdrawal by Carter without the concurrence of 2/3 of the members of the Senate. And the reason, I suppose everybody already knows because I have repeatedly stated this. It is a political question. The conduct of foreign relations is the exclusive prerogative of the President, for which he is responsible only to the people. And that is the essence of a political question. The voice of the people is the voice of God. And we have a precedent in Philippine jurisprudence, and that is the case of Pimentel versus Estrada. Now, Pimentel versus General Ermita, where in that case, the Senate filed a case for mandamus against the Office of the President to send to the Senate for concurrence the Rome Statute, creating the International Criminal Court with universal jurisdiction. The Supreme Court held that the Supreme Court cannot compel the President to submit the Rome Statute creating universal jurisdiction of the ICC to the Senate for concurrence. Number one, it is a discretionary power of the President to submit or not. And a discretionary function cannot be compelled by mandamus, because mandamus applies only to duties specifically enjoined by law, where no discretion is involved, but as a matter of duty must be done. Where what is being compelled by mandamus is a discretionary power, mandamus will not lie. Mandamus applies only to duties specifically required or mandated by law. And that is also the case of Garcia versus Executive Secretary on and Mandanas versus Executive Secretary on the allotment 40% of all the taxes, national taxes collected by the government. So, it's a lesson in remedial law. And under the Vienna Convention, in addition to the political question involved, it is the authority that can ratify a treaty who can withdraw from a treaty. And which authority has the power to ratify the treaty? Only the President. Only the President may ratify. with the concurrence of 2/3 of all the members of the Senate. The power of the Senate is only for concurrence. And so, the Supreme Court did not compel the Executive Secretary to refer or to send the Rome Statute to the Senate for concurrence. Undaunted, then Senate President Aquilino Pimentel Sr. passed a law adopting in part the Rome Statute. And what is very important with respect to this law, which I believe has been hidden from the public, even lawyers are not aware of this. And other bar reviewers are not even aware of this. Because I think it was in 2009 when this was adopted, this law, incorporating the universal jurisdiction on crimes against humanity. I do not know if it was published in the official gazette. Maybe it was. But it was not published in a newspaper of general circulation. So when I was discussing this, even bar review students in UP and Ateneo were not aware of this law. Now, this is in my study guide. I summarized this, and the laws or offenses against crimes against humanity are adopted here, including extrajudicial killings and abuses of heads of state and agents and instrumentalities of government. And the most important portion that was incorporated in this law is the principle of superior responsibility, that a head of government office is responsible for the negligence and the illegal acts of the subordinate. And this is adopted with respect to public service in government, which is already internationally recognized in the military, and that is command responsibility. Command responsibility has been incorporated in this law, which is part of the Rome Statute, because the Rome Statute is a Bill of Rights against abuses of heads of state and government agents. And that is the reason why the International Criminal Court has been granted universal jurisdiction against extrajudicial killings and other crimes against humanity like genocide and violations of international humanitarian law. I suppose this is still part of public international law, although it has a bearing in the law on procedure, evidence, and remedial law. The Arias Doctrine. I believe that the Arias Doctrine meaning that the heads of office have the right to rely on the recommendations of their support staff, has been abandoned by the domestic adoption of the Rome Statute, embracing and upholding superior responsibility. Because under the Rome Statute, the guiding principle is superior responsibility. The head of office is supposed to know what the subordinate officers are doing and is responsible for the negligence, malfeasance, misfeasance, nonfeasance that cause damage or injury committed by the subordinate. And not only is that, in the local adoption of the Rome Statute, enacted during the time of Senate President Aquilino Pimentel, when the Rome Statute creating universal jurisdiction vested in the International Criminal Court was reaching the deadline. The deadline was December 31, year 200. Our Ambassador Plenipotentiary, Ambassador Manalo, signed accession to the multilateral treaty known as the Rome Statute, creating the International Criminal Court, vesting universal jurisdiction on the ICC. The United Nations sent the Rome Statute to the Department of Foreign Affairs, then to President Gloria Macapagal Arroyo. President Arroyo, who was aligned with the President of the United States, refused to ratify the Rome Statute and refused to send the Rome Statute to the Senate for concurrence by two-thirds vote of all the members of the Senate. In view of this refusal, Senate President Aquilino Pimentel sued General Ermita by mandamus, to compel by mandamus to send the Rome Statute to the Senate for concurrence. Undaunted, he filed a case for mandamus, but as I have earlier told you, he lost the case on the ground of it is a political question beyond judicial review by the court. Anyway, you can, it is in one of my handouts, I summarized it. Aquilino Pimentel caused Congress to enact a law adopting the Rome Statute with universal jurisdiction. Unfortunately, this was not widely disseminated, but there is such a law adopting the Rome Statute. Anyway, the issue is null and void, not null and void, I'm sorry. The issue is moot and academic because during the time of Noynoy Aquino, he ratified the Rome Statute. So we were, for a while, under the jurisdiction of the International Criminal Court on universal jurisdiction, including extrajudicial killing, until President Duterte withdrew from the jurisdiction of the International Criminal Court, which is still, which withdrawal is still pending in a case filed by the senators to declare null and void the withdrawal for lack of concurrence of the requisite two-thirds vote of the Senate. So it is still pending, and if I would be an examiner, if I were an examiner, I would ask this question. So we will guide the members of the Supreme Court on the proper way of dealing with the issue. Now, what is a political question? It is a question of policy and wisdom of a particular measure. It refers to those questions which under the Constitution are to be decided by the people in the exercise of their sovereign will. Is the political question doctrine still in effect in the light of the power of judicial review over acts of the legislative, executive, their subordinate officers and instrumentalities which are tainted with grave abuse of discretion, which by express provision of Section 1, Article 8 of the Constitution is subject to judicial review on grave abuse of discretion or acts tantamount to excess or lack of jurisdiction. The answer is, if it is a matter of grave abuse that involves the welfare of the people, why not? The Supreme Court can assert jurisdiction. And it does not matter whether the Supreme Court can implement its order or decision to the office of the President. In the case of Chief Justice Marshall of the United States Supreme Court, he said, "I have done my duty to interpret the Constitution and make the proper ruling, and whether or not it is respected by the executive is beyond me. It is enough that I have done my duty under the Constitution." There is a statement in Bayan, Bagong Alyansang Makabayan versus Zamora, 342 Iskra 449, promulgated year 2000. That the present Supreme Court under Section 1, Article 11, has broadened the scope of judicial inquiry into areas formerly left to the political departments to decide, such as those relating to national security. It has not altogether done away with political questions such as those which arise in the field of foreign relations. So, in the constellation of competing constitutional values, the Supreme Court is allowed to make an evaluation of which value ranks higher than the other. Now, in relation to the case of Maria Lourdes Sereno, I think a question on impeachment might be raised. Quo warranto versus impeachment, where the prior ruling before the Sereno dismissal as Chief Justice of the Supreme Court is that constitutional independent officers, President, Now, Vice President, you read the provisions of the Constitution. President, Vice President, Chief Justice and members of the Supreme Court, heads of the constitutional bodies, COMELEC, COA, Ombudsman, Senate President, maybe no, not the Senate President. President, Vice President, members of the Supreme Court, members of the Constitutional Commissions, and the Ombudsman may be removed only by impeachment. And also, Chief Justice and members of the Supreme Court. Why was Sereno, who had a pending impeachment case before Congress, removed by way of quo warranto? Anyway, I think we have discussed that already. I will not repeat my reasons why. Just answer the question: what are the grounds for impeachment? Culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, and betrayal of public trust. Under statutory construction, it must be on the same level of heinousness and seriousness as those enumerated. Failure to state in the assets and liabilities certain assets, depending upon the circumstances and surrounding facts of the case, may not constitute betrayal of public trust. When Chief Justice Corona was being impeached, I was handling a parallel case against a head of the warehouse department of the Bureau of Customs for failure to state in her statement of assets and liabilities one lot on which her house in Quezon City is constructed. And actually, there were two lots, but she reported only one lot, and for failure to report one lot and another lot in Bicol, which has been sold a long time ago, but still the tax declaration is still registered in her name, she was sued for falsification in the RTC of Manila. I defended her and I got an acquittal because I said, violation under the Code of Professional Conduct and Ethical Standards of Public Officers and Employees and the Anti-Graft and Corrupt Practices Act. Although punishable by special penal laws, the Anti-Graft and Corrupt Practices Act, still the charge or the offense is taken from the revised penal code, falsification, which requires criminal intent or dolo, deliberate criminal intent. And I said that we have produced evidence that I submitted before the court that indeed the lot in the farmland in Bicol was already sold many years ago. And I presented as evidence the deed of sale, although it was not registered by the buyer. And also, I argued that there is no criminal intent with respect to failure to state in the statement of assets and liabilities the other lot, because anyway the house and one lot was reported, and so that is by excusable negligence or mistake, which is an excusable fact or circumstances. I got an acquittal on the violation of failure to include certain properties. But what is the definition of criminal law? It is a part of public substantive law that defines crimes and provides or impose penalty. And what is the penalty involved for failure to state, for failure to include certain items in the statement of assets and liabilities? There is none. The only thing that the law requires is that the statement of assets and liabilities be so amended to include the excluded assets and liabilities. There is no law punishing or imposing penalty for exclusion of certain assets and liabilities in the statement of assets and liabilities, because it is a crime mala in se. It is a concept, in case of falsification, borrowed from the revised penal code, which is committed by dolo. And so, I got an acquittal. I was volunteering to be a defense counsel for Chief Justice Renato Corona. He was the godfather of my son, and he was a friend from San Jose, Batangas. His brother studied Doctor of Laws with me, Dr. Arturo Corona, at the University of Michigan. And so we were friends, and his father, Attorney Juan Corona, was a best friend of my father-in-law, Attorney Perfecto Ladisma Kagampang. So we are friends, and I wanted to defend him. In fact, I was instrumental in having him appointed because I filed a mandamus suit against the JBC to submit nominees to President Gloria Macapagal Arroyo, and the rest is history. He was appointed because the Supreme Court directed the JBC, even during the election ban, to submit for possible appointments as Chief Justice 3 nominees on the theory that I developed that the anima lehis of the prohibition does not apply to appointment to the position, vacant position of Chief Justice, which will not affect or influence the result of the election. And that is now in jurisprudence, Arturo M. de Castro versus JBC. Now, the Francisco versus House of Representatives, with respect to when is an impeachment complaint deemed initiated, because there is a prohibition in the Supreme Court that you cannot file another impeachment case within 1 year. And the answer in Francisco versus House of Representatives is the first petition is deemed filed when it is referred to the Justice Committee. And it is referred to the Justice Committee upon receipt of the Justice Committee. Now, let us now go to what is happening in Congress. I got a post just this morning that Richard Gordon is fearing for his life for opposing the president, and I just made a simple repartee saying that Gordon used to be a protector and ally of the president in the Senate investigation. Now he is now grandstanding and violating due process of law to boost his ambition to be elected president. And this is not the time. And besides, he is not qualified because he is not neutral and independent to investigate at this political season and right away targeting the president when he has no power to investigate the president. He cannot even call the president. The president is immune from suit, although he has the freedom of speech and he has the entitled to free expression, but there are limitations, and he should obey the basic requirements of due process. Hear before you condemn. Finish the trial before you render judgment, and let the evidence speak for itself on the innocence or guilt. Do not prejudge, do not condemn, because we have an accusatorial form of government, not inquisitorial, where you presume the guilt and you look for evidence to support your prejudgment. Ang kalawang po ang sumisira sa bakal. And that goes into the character of loyalty of a person. At yung po naman kanyang ginagawa sa PAGCOR, hindi po siya ang Red Cross. Siya po ay senador ng bayan at siya ay nagpapasiya, pagpapasa ng batas, kamukha nitong pandemya, the law on bayanihan to heal as one. Binigyan po ng emergency power ang Executive Department to address the COVID pandemic. Ngayon po, bakit sinasabi ni Gordon na graft and corruption dahil daw walang bidding? Wala pong public bidding in case of emergency exercise of power. Emergency purchases justifies doing away with bidding. And that is a well-known principle in administrative law. Ay bakit sinasabi niya na grab daw dahil walang bidding? Ay kaya nga po emergency. And dahil po sa kanyang pamimersonal, right away sinasabi niya na corrupt si Presidente, na hindi pa naman natatapos ang kanyang pag-uusisa sa panahong hindi naman nararapat dahil panahon na nga po ng kampanya, and he is mounting before the Senate in the guise of investigation in aid of ambition. At sinasabi na agad niya na mayroon siyang conclusion at kanya raw iimbestigahan ang presidente. He cannot. Because the teaching of David versus Ermita is very clear. The president may prohibit subordinate officers in the executive department. Without his consent, they cannot appear. Although the principle is that if it is an investigation in aid of legislation, then the power of the Senate is absolute. But considering the special facts and circumstances that this is already election period and he is disqualified because he cannot be an investigator and a prosecutor and a witness at the same time. But anyway, sinagot ko po sa aking comment na pinalalabas daw na let us come to the aid of Richard Gordon because he is cowering in fear for the great risk to his life. Ay, again, jumping to conclusion, ay si Gordon po naman ay alay at protector niya sa lahat ng investigasyon sa Senado. Pagkatapos ngayon, he is grandstanding during the time of election. Hindi pa nakakapag-imbestiga, ay nanghuhusga na kaagad. Ay bakit sasabihin na natatakot? Ay kung totoo po na ang opposition ay pinapatay, ay bakit po ang ating kaibigan na si Trillanes, na talaga namang naninira ng walang basihan, ay buhay pa ho hanggang ngayon. Ang napapatay lamang naman ho ay yung mga drug lords. Hindi ba kayo natutuwa na nililinis ang ating bayan ng mga masasamang elemento? At ang sinasabi ko lamang doon sa hindi konforme sa aking pananalig, dahil ako po ay nag-practice ng law 15 to 20 years sa Davao. Pinagpatayo ko ng bahay ang aking anak doon at siya po ay nag-aral sa Ateneo de Davao. Dahil ang bayan po naman ng asawa ko ay malapit lamang, 3 oras by good road, good highway, naroon na kami sa Davao at nakita ko po naman na siya ay minamahal ng mga taga Davao at kinatatakutan ng mga bad elements. Ang hinihingi ko po lamang doon sa aayaw sa presidente, kaunting galang lamang po sa amin na naniniwala sa kanya, have respect and exercise respect and sobriety doon sa mga detractors. Do not argue with anger at mangampanya na lamang po kayo sa inyong mga gustong kandidato na pinaniniwalaan ninyo and let the people decide. The voice of the people is the voice of God. At doon po sa opinionated na sinasabi ninyo at mga conclusion ninyo, kaunti lamang pong respeto dahil iwasan po natin ang makasakit ng damdamin sa ating kapwa. At nang sa ganun po ay tayo po ay magalangan, igalang natin ang isa't isa. So tapos na ho yan kay Gordon. Ito ang summary ng powers of Congress. State the power of Congress to call executive officials to attend congressional investigation. Number 1, investigation in aid of legislation. Absolute right to compel appearance. Gayon, kung nag-exercise ng executive privilege ang presidente at ayaw pa-appearin, anong gagawin? You cannot take the law into your own hands. Go to court. Ito, what is executive privilege? For reasons that must be stated, confidentiality to safeguard national interest. The President may restrain cabinet officials from attending congressional investigation. Has the President the constitutional power to declare state of rebellion, state of national emergency, martial law? Ayan, pinakyaw ko na. Yes, under the under his constitutional powers as Commander-in-Chief and as Chief in charge of faithfully executing the law. Has the President the power to take over public utilities during a state of national emergency under the present state of the law and the Constitution? Answer, no. In the absence of implementing legislation granting the President such emergency power, the President cannot take over public utilities during a state of national emergency. The constitutional provision of emergency powers of the President in case of national emergency is not self-executing but must be delegated by the people. Now, these are summaries from Judicial Decisions interpreting the provisions of the Constitution. Do the police have the power to make warrantless arrests during a state of national emergency? Answer, no. Without legal grounds under existing law, namely, a crime is being committed or is about to be committed in the presence of the police, or a crime has in fact been committed and the police has reasonable ground to believe that the person to be arrested is the author of the crime. That is the essence of probable cause. And in the Sabla decision, the mere fact that there is an informant pointing to the commission of the crime, it is not sufficient probable cause for the police to make an arrest without making proper investigation. And that is to safeguard the people from being subjected to harassment without due process of law. Because probable cause to warrant search, seizure, and arrest without a warrant must be based on the existence of facts and circumstances engendering in the mind of the police officer that the person to be arrested is probably the author of the crime. I don't know, without that, under the Bill of Rights, no person shall be deprived of life, liberty, or property without due process of law. So look at the second. A crime has been committed and the police has reasonable ground to believe, based on the facts within the knowledge, that the person to be arrested is probably the author of the crime. And another, in case of hot pursuit of an escaped prisoner. Now, there has been no question in constitutional law and public international law on citizenship. So, please study dual citizenship, because there is a jurisprudence already here on dual citizenship. Is dual citizenship constitutional? The answer is yes. I will not read the question. Just read Kalilong versus Datu Manong, GR number 60869, May 11, 2007. What is the mode of acquiring citizenship? Dual citizenship by a Filipino who has lost citizenship by acquiring foreign citizenship. Now, which country recognizes dual citizenship? US, Canada, Australia, Switzerland. May dual Filipino citizens residing abroad and overseas Filipino be allowed to vote? The answer is yes. And there are three reasons given by the Supreme Court. I might not be able to cover all, so just read. Loida Nicolas Lewis et al. Versus Comelec, GR number 162759, August 4, 2006. Is a green card holder with permanent residence in the U.S. eligible to hold public office? The answer is no. Now, Tanyada versus Angara, 272, Iskra 18. You read this. On the provision of the Constitution on the exploitation, on partially nationalized activities, and the accession of the Philippines to the Maracas Treaty, joining membership in the World Trade Organization, where the principle is equality of treatment among nationals of members country to the WTO. Are we not in violation for reserving land ownership to Filipino citizens or to 60-40 corporations, 60% of which is owned by Filipino capital? That runs counter to the principle of globalization and equality of treatment. And that's why our country managers or previous administration tried very hard to amend the Constitution to open up land ownership to foreigners, because it is contrary to the principle of equality of treatment. We can own land in the United States, but U.S. citizen cannot own land in the Philippines. Of course, they can do that by resorting to 60-40 corporate land ownership. And so that is the reason why past administrations have attempted to amend the Constitution, not only to shift to another form of government, but most of all, to align ourselves to the requirements of equality in treatment among member nations, among nationals of member nations of different countries of the world who have acceded to the Maracas Treaty to be members of the World Trade Organization. Now, how do treaties become part of domestic law? The Philippines renounces war as an instrument of foreign policy and adopts the generally accepted principle of international law as part of the law of the land. And that is by incorporation, adoption by constitutional provision. And the other one is transformation through legislation. So by transformation, the Rome Statute was adopted by our Congress during the time of Nene Pimentel, Aquilino Pimentel Jr. when he was Senate President. Now, the right to bail. What is the basis for the right to bail of a person under extradition. I think I have discussed extradition before in the last hearing, and in the Purugunan case, it was held that the owner of Bulletin Today, who was extradited, at that time, the decision of the Supreme Court is that an extraditee is not entitled to bail because extradition is neither criminal nor administrative. However, in the case of Rodriguez versus RTC Manila 2006 decision and Hong Kong versus Ulalia April 19, 2007 decision, the Supreme Court reversed itself and held that under the international human rights, that any person under detention has the right to bail. And you know the requirements under the Constitution. Bail is a matter of right. If the crime is not a capital offense, and even if the crime charge is a capital offense, punishable by reclusion perpetual, 12 years and 1 day to 40 years, because the death penalty has been abolished in this jurisdiction. Still, even in capital offenses where the evidence of guilt is not strong, then the accused is entitled to bail. Grounds for warrantless arrest. Warrantless search and seizure. This is the case on warrantless search and seizure. Let me just go through it. Voluntary waiver or consent, as when the accused checked in his luggage in the airport. When there is valid reason to stop and frisk, as when the public chanced upon the accused, who had reddish eyes, walking in a swaying manner, appeared high on drugs. Search incident to a lawful arrest. Search of vessel or aircraft. Search of moving vehicle. Now, Plain View Doctrine, requisites prior valid intrusion based on the valid warrantless arrest in which the police are legally present in the pursuit of their official duties. The evidence was inadvertently discovered by the police, who have the right to be where they are. The evidence must be immediately apparent. Plain view justified the seizure of evidence without any further search. And then, here is what I added. Under exigent and emergency circumstances, such as during coup d'etat and state of rebellion. And I picked this up in People versus De Garcia, 233 Iskra 716. Now, what is the knock and announce principle in search of search warrant? Now, you will find the answer in People versus Huang Xin-Hua and Jogi Lee, GR number 139301, September 29, 2004. What are the requisites of judicial review? There must be an actual controversy. The constitutional question must have been raised by the proper party at the initial opportunity. And the requisite now for the Supreme Court to entertain discretionary jurisdiction is in favor of a party who has who will suffer a direct personal injury apart from the generally shared injury with the public, and which is a stricter rule on legal standing or capacity to sue. Because whereas before, in the Pascual case, as long as disbursements of public funds are involved, any Tom, Dick, and Harry ay citizen, ay taxpayer, may file a suit and question acts that involve public interest or what is called of transcendental importance to the nation, that is related to public interest and transgression of public duties. But the Supreme Court has now adopted, in the exercise of discretionary power, whether to grant due course or not, the personal and direct injury case to grant legal standing or capacity to sue to a petitioner in important and mighty constitutional issues cases. And that was the fate that befell on my declaratory relief petition to diffuse the tension when Tito Soto and Pantaleon Alvarez were quarreling on the proper interpretation of the Constitution, on whether the voting for amendment or revision to the Constitution would be per capita or each house voting separately. My petition was denied because I appeared to be, in the view of the Supreme Court, asking for an advisory opinion because I am not a senator and I am not equipped with proper personality because I am not directly and personally affected by the issue. Although I am a citizen and a public interest lawyer who has been able to raise high and mighty constitutional issues before the High Court. So the constitutional issue must have been raised for the at the earliest opportunity, and the decision on the constitutional question must be determinative of the case itself, that is, would settle and adjudicate on the conflicting claims of the parties who are directly affected by the decision or by the case. Now, to justify discretionary assumption of power by the Supreme Court, you see, the Supreme Court, in order to serve the ends of justice, may set aside the technical rules. For example, a petition for declaratory relief falls within the exclusive jurisdiction of the regional trial court. However, where public interest is involved and constitutional questions are raised affecting the public welfare, public interest, the Supreme Court may exercise the discretionary power to assume jurisdiction and resolve the case. That is a discretionary power that may be exercised by the Supreme Court under its jurisdiction in equity, or exercise of equitable powers pursuant to Section 1, Article 8 of the Constitution, granting the Supreme Court the power of judicial review over acts executed by the executive and the legislative departments, their subordinate agencies and instrumentalities that are tainted with grave abuse of discretion, tantamount to excess or lack of jurisdiction. This is a power of the court in equity, which the court has the equitable power to exercise, even in the absence of such provision in the Constitution, because our courts are both courts of law and courts of equity. Now, question. May an inferior court declare a law or a treaty unconstitutional? Or is it reserved to the jurisdiction of the Supreme Court? Because where the case involves the constitutionality of a treaty, it falls among the enumerated jurisdiction of the Supreme Court in writ of errors, writ of certiorari provided in the Constitution. So here is a question. May an inferior court declare a law or a treaty unconstitutional? Or is it reserved only to the Supreme Court under the enumerated powers of the Supreme Court to declare a law or a treaty unconstitutional? The answer is yes, if it is necessary to adjudicate on an issue, to resolve an actual controversy between two parties in interest. Now, let us go to election, because this is election year. This has not been asked, this question. May irregularities in the conduct of election be raised in a pre-proclamation case? The answer is no. Irregularities in the conduct of elections, such as substitution of returns, terrorism of voters, and use of flying voters, refer to the conduct of the election and cannot be raised in a pre-proclamation case. Now, pre-proclamation controversies, which can enlarge a proclaimed candidate. Under Section 241 of the Ombudsman Election Act, any question pertaining to or affecting the proceedings of the Board of Canvassers, which may be raised by any candidate or by any registered political party or coalition of political parties before the board or directly with the COMELEC. What issues may be raised in the pre-proclamation controversy? Illegal composition of proceedings of the Board of Canvassers. The canvass election returns are incomplete, contain material defects, or appear to be tampered, or which contain discrepancies. The election return were prepared under duress, threats, coercion, or intimidation, or they are obviously manufactured or not authentic. when substitute or fraudulent returns in the controverted polling places were canvassed, the result of which materially affect the standing of the aggrieved candidate or candidates. Are pre-proclamation controversies allowed for election in national offices? Why? Why not? No. Pre-proclamation controversies are not allowed in national election. The answer is Pimentel, the third versus Comelec. GR number 1748413, March 13, 2008. Another issue is the invalidation of the proclamation without a protest. The answer is Espidol versus Commission on Elections. I think I handled this case in Bicol when I was a younger lawyer. 472 Iskra 380. Execution pending appeal. The problem is that with respect to election protest, even on local and national elections, the next election is already approaching. The protest has not been terminated. I handled a case in Bohol where my client lost in an election protest in the RTC. So I appealed to the Court of Appeals. I lost. I appealed to the Supreme Court. The election took place without my case being decided by the Supreme Court. But my client lost in the election because the people knew that he did not win the election. So, election lawyers or those of you in the provinces, just remember that execution pending appeal is allowed before the Supreme Court or before the appeal is taken to the Comelec. Execution pending appeal may be availed of in the regional trial court that rendered a decision in favor of your client, or if it is already appealed to the Court of Appeals, the appeal to the Comelec, the appeal has ousted jurisdiction to act on the case from the regional trial court. You go to the Comelec and you apply for execution pending appeal, and there is no need for a bond where in the view of the court or the Comelec, your client has really won the case. There is no need for appeal bond. And that is the case of Balgonda versus Comelec. 452 Iskra 642. It is expressly authorized by Section 1, Rule 41 of the Comelec Rules of Procedure. And the only reason, the only ground is there must be good reasons. If it is very patent that your client has won the election, that is good reason enough for execution pending appeal. Now, we have discussed this. What are the grounds to declare failure of elections? No election on account of force majeure, violence, terrorism, and fraud. Election is suspended before closing for the same grounds. Force majeure, violence, terrorism, and fraud. Now, force majeure, COVID pandemic, where there is a lockdown, how can people go to vote? And there is no law allowing voting by mail. Under the exigent facts and circumstances, election probably should be postponed because anyway, it would result to failure of election. And third ground for declaring failure of election, after voting and during the preparation, transmission, custody, or canvass, the election results in failure to elect on account of any of the foregoing causes. What is the void for vagueness doctrine? Estrada versus Sandigan Bayan. Exhaustion of administrative remedies. Before going to court, you have to exhaust administrative remedies. And under the related doctrine of primary jurisdiction, it is the body with primary jurisdiction that must initially do the investigation. And one example of that is central bank. The central bank, before it can close a bank, must conduct an investigation. And if it is a violation of central bank rules and regulations, you cannot go to the fiscal's office or the Department of Justice and file a criminal case for infraction of protocols or provisions on banking without initial investigation by the Bangko Sentral ng Pilipinas under the doctrine of primary jurisdiction. The same case where it is an agrarian, there is an agrarian dispute. You cannot file a case for qualified theft against tenants without first filing a case for investigation before the Department of Agrarian Reform. That is the doctrine of primary jurisdiction. So the another case, you cannot file an impeachment or a crime or prosecution before the Office of the Ombudsman for violation of the Anti-Graft and Corrupt Practices Act against a judge, say for rendering a manifestly erroneous judgment or any violation of the Anti-Graft and Corrupt Practices Act, like granting undue favor to a party or gross negligence in the exercise of judicial functions, or causing undue damage or injury to any party, including the government. That falls under the jurisdiction of the Office of the Ombudsman under the Anti-Graft and Corrupt Practices Act for preliminary investigation, and then before the Office of the Ombudsman for crimes committed by public officer where the penalty imposed would where the employees involved have a salary grade of more than 27. Now, you cannot, under the principle of primary jurisdiction, without first filing a complaint, let us say for rendering a manifestly erroneous judgment. You cannot file a case directly with the ombudsman against an errant judge, because under the doctrine of primary jurisdiction, you must file first a case before the judicial administrator or with the Supreme Court. And if there is an adverse finding, that's the only time that you can go to the office of the ombudsman. And that is the doctrine of primary jurisdiction in criminal prosecution. Exhaustion of administrative remedies. There is no need to exhaust administrative remedies where you are aggrieved by the acts of any tribunal. Under Rule 65, where the respondent, whether a court or agency of the government, has acted with grave abuse of discretion, you have the right to file a petition for certiorari under Rule 65 on grave abuse of discretion. Certiorari, prohibition, and mandamus under Rule 65. And the jurisdiction of the RTC, the Court of Appeals, and the Supreme Court are concurrent. But do not forget the doctrine of the hierarchy of courts. You must start with the RTC. Let us say under where the respondent is the RTC judge, you file first with the Court of Appeals before going up to the Supreme Court. The issue, or rather the jurisdiction of the Supreme Court to entertain petition under Rule 65 on grave abuse of discretion is discretionary, and there are requirements for the Supreme Court to exercise its discretion to give immediate due course if you bypass the lower court under the doctrine of the hierarchy of courts. And number one, the personality, the petitioner must be vested with personality to sue, and capacity to sue may be based on direct personal interest, not the interest generally shared with the public. And number two, there is an actual controversy involving the petitioner where the conflicting rights have to be adjudicated. And number three, the issue must involve public interest of transcendental importance to the nation. And what is the meaning of that? It affects public interest. There is no need to exhaust administrative remedy where the only issue is purely legal in nature, and there is no need even to file a motion for reconsideration if you are raising a purely legal question, particularly if it is a high and mighty constitutional issue affecting paramount public interest. What are the two instances under the Foreign Investment Act when a foreigner may own lands in the Philippines? By hereditary succession, And under the Foreign Investment Act, a former Filipino citizen coming home as a balikbayan may own lands in the Philippines, even if remaining a foreigner. But it is limited only to 500 square meters of commercial or urban land, and no, not urban, commercial, yes, urban land, and 3 hectares, rural land not exceeding 3 hectares. A controversial issue is with respect to the power of the investigatory arms of government, particularly the Department of Justice, the NBI, and even the CIDG, to investigate public officials who are removable only by impeachment. Those who cannot be charged, who cannot be removed except by impeachment, and therefore interpreted by some as enjoying immunity from suit. So when the computerization fiasco in the COMELEC took place, COMELEC officials were charged before the Supreme Court, or rather hailed before the Supreme Court, and the Supreme Court ordered the Ombudsman to investigate COMELEC officials in the computerization fiasco, charged laden with graft and corruption. The office of the Ombudsman, then held by Ombudsman Gutierrez, was in a quandary, because the jurisprudence is that officers who are removable only by impeachment are immune from investigation, from being charged civilly, administratively, or criminally during their term of office. But there is a decision of the Supreme Court in Estrada to the effect that under Section 22 of the Ombudsman Act of 1989, the Ombudsman has the power to investigate all errant public officials, and by this, those who are removable by impeachment are not exempt from investigation by the Office of the Ombudsman under Section 22 of the Ombudsman Act of 1989. So, what did Ombudsman Gutierrez did? She investigated and then filed complaint for impeachment in the in Congress. So that's what she did. So you have, as long as you know the principle And who are the officers who are immune from suit? And I repeat, President, Vice President, Supreme Court and its justices, and then independent constitutional bodies, COMELEC, COA, Office of the Ombudsman. Cannot be removed except by impeachment because they enjoy security of tenure or immunity from suit, civil, criminal, administrative, during their tenure of office. Let us not repeat what we discussed on Sereno. Just read the case. And remember what I am introducing as a possible ground that as a matter of equity, although it is not provided in the Constitution or in the rules of a body has the inherent equitable right to expel its member under the principle of exigency of the service. It is an act of policing itself as a matter of collective self-defense to maintain the integrity and the faith, trust, and confidence of the people to the particular body. Although in the case of the Senate, when I cited the case of Tañada versus Cuenco, there is a rule for the expulsion of members in the Senate. But even without that rule, it is the inherent right of self-defense of a collegial body to expel an errant member. Now let us in international law, when is war justified? Under international law, as a matter of self-defense. When is war justified under international law? One, as a matter of national self-defense. When there is unlawful aggression, then it is the right to self-preservation to defend the country against foreign aggression. And that is the principle of national self-defense. And then war is justified when supported by a resolution of the UN Security Council. But the composition of the UN Security Council is something that is one-sided, because China is and the other 5 countries, China, US, France, Germany, United States, they exercise a veto power. The big 5 nations who won the Second World War have a veto power in the Security Council of the United Nations, because while there are 15 rotating members, the 5 permanent members must unanimously accede to a resolution of the UN Security Council to pass. And with one objection, let us say from China, then a resolution in favor of all the overwhelming majority of all the member nations will not pass before the Security Council of the United Nations. What are the forcible measures short of war for settlement of international disputes? Severance of diplomatic relations, retortion, reprisal, embargo, boycott, non-intercourse, Pacific blockade, collective measures under the UN Charter. Now, explain the concept of pacta sunt servanda. Now, this is a very important principle, a peremptory rule, generally recognized as jus cogens, or mandatory, generally accepted principle of international law. Pacta sunt servanda. Treaties must be performed in good faith. And then a most favored nation clause. If there is a most favored nation clause, then in a treaty, then that must be covered. This is illustration. When my son was buying a house in the United States, and that was before the bubble of the real estate business burst, and so we made a deposit of $10,000, and I put a most favored party clause in the reservation agreement, that I say that any terms and conditions that might be favorably granted to any party shall be accorded to us. And so the construction was finished at the time that we are supposed to make a payment. Can you imagine? The price of real estate were brought down very drastically from 1 million per house and lot to only 600,000 US dollars. And so we said, we are entitled to that. You have to bring down the price, because that is covered by the most favored party clause. So I'm using that as an example, that if we have a more favored nation clause in a treaty, and another country is given by the other contracting treaty party with us a more favorable treatment, then we can invoke that we are entitled to that. That is the meaning of most favored nation clause, which is also part of the agreement between the parties in a contract. So we got a very substantial discount, and we were able to buy more furnitures because of the big discount that was granted to us under the most favored nation clause, most favored party clause in the reservation agreement. Rebus sic stantibus. A party to a treaty is discharged in the event a change of circumstances occurs which renders the fulfillment of the treaty grossly unjust, oppressive, and iniquitous. So that is rebus sic stantibus, which is the equivalent of the doctrine of the supervening event that I have pounded repeatedly. Now, what are the limitations on the doctrine of rebus sic stantibus in international law? It applies only to treaties of indefinite or perpetual duration, not applicable to treaties that are completely executed prior to the change in the circumstances. a party who caused the change in the circumstances is not entitled to the benefit of rebus sic stantibus, because he cannot profit from his own malevolent act. If you are the proximate cause, you cannot benefit for the for something under the principle of unjust enrichment. And the change of circumstances should have been unforeseen at the time of the conclusion of the treaty. Now, this is very important. Rome Statute, and this has been adopted by local legislation that I was mentioning earlier, which has not been publicized until now. But I have a summary of this in my handouts. And these are lifted from the Rome Statute, creating the International Criminal Court vested with universal jurisdiction. The International Court of Justice, ICC, has jurisdiction over the following crimes. 1. Crime of genocide, that is killing a race or a tribe. Crimes against humanity, and crimes against humanity have so many illustrative examples. War crimes and crimes of aggression. Now, all these have definite meaning or have definite composition or definitions in the Rome Statute, copied and repeated in the adoption of universal jurisdiction by Nene Pimentel while he was the Senate President. Then, what is genocide? So, intend to destroy in whole or in part a national, ethical, racial, or religious group, killing members of the group, causing serious body or mental harm to members of the group. Deliberately inflicting on the group conditions of life calculated to bring about physical destruction in whole or in part. And even imposing restrictions to prevent births and population growth. Forcibly transferring children of the group to another group. Just what Trump tried to do among Mexican children being separated to their parents. What are the crimes against humanity? Any of the following acts committed as part of a widespread or systematic attack directed against any civilian population with knowledge, murder, extermination, enslavement, deportation or forcible transfer of population, imprisonment or other severe deprivation of physical liberty in violation of fundamental rules of international law, torture, rape, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, or any other form of sexual violence of comparable gravity. Persecution against any identifiable group or collectivity on political, racial, national, ethical, cultural, religious, gender, as defined in paragraph 3, or other grounds that are universally recognized as impermissible under international law in connection with any act referred to in this paragraph or any crime within the jurisdiction of the court. Meaning of enforced disappearances. Now, this is very important because we have the writ of amparo issued during the time of Chief Justice Ray Puno, the writ of amparo, which is a remedy against constitutional violations by heads of government and government instrumentalities. This is a related constitutional remedy to writ of habeas corpus. So when the writ of amparo was asked, so many students could not answer because we do not have this concept in the Constitution, in our body of laws. But this is well developed in other countries which had protection against constitutional infractions by government. So when this was asked, what is the writ of amparo? No, most of the bar reviewers, barristers, did not know the answer. And so some of them, better giving an answer by guesswork than blank, answered, the writ of amparo is the wife of the writ of habeas corpus. And if I were the examiner, I would give credit to that because it is related to the remedy against constitutional violation. Enforced disappearances. This is defined as extrajudicial killings committed by the government, by the agents of the government. And so under the writ of amparo, where under a writ of habeas corpus, a case is filed in court and the respondent police officer made an answer or a reply. The warm body of the respondent is not with us. That's the end of the case. And I know this because for almost 40 years, I was a volunteer private lawyer of the PNP in Batangas when General Villafranca and my other friends were still in the police service. General Villafranca was the intelligence officer, number one sharpshooter among the police officers during my time when I was working with them. And so when a writ of habeas corpus is filed against any one of them, I will just make a report. It's not with our custody. And so that is the end of the inquiry. Because if the respondent is in the custody of the police officer or the police, then under the writ of habeas corpus, the warm body must be brought to the court. The writ of amparo gave further remedies. In case the victim has been buried 6 feet below the ground in the compound of the police station, the writ of amparo would give the petitioner a right to search the premises of the police in order to find out the whereabouts of the police who might have been buried there. Because while it is true that the body is not with the respondent, but he is buried somewhere, and if there are witnesses, then further inquiry, further reliefs may be granted by a writ of amparo court. So the writ of amparo is a measure augmenting the writ of habeas corpus to grant reliefs in case of enforced disappearances. And enforced disappearances, by definition of the Rome Statute, include extrajudicial killings by the police. What are wire crimes? It's already 12:10, but if you want me to continue, just to finish, I will just leave it up to you to read the enumeration of jurisdictions under the Rome Statute. And can you imagine? It took about 8 pages to enumerate what are those universal crimes under the International Criminal Court. So you can just read the Rome Statute. I suppose that is available. What is the meaning of enforced disappearance of persons? The arrest, detention, or abduction of persons by or with the authorization, support, or acquiescence of a state or political organization, followed by a refusal to acknowledge that deprivation of freedom, by a refusal to acknowledge that deprivation of freedom, or to give information on the fate or whereabouts of those persons with the intention of removing them from the protection of the law for a prolonged period of time. Define the writ of amparo. A remedy available to any person whose right to life, liberty, and security is violated or threatened with violation by an unlawful act or omission of a public official or employee or a private individual or entity, including extra-legal killings and enforced disappearances of threat thereof. This is Section 1 of the writ of amparo issued by the Supreme Court during the tenure of Chief Justice Ray Puno, quoting from the provision of the Rome Statute, granting universal jurisdiction to the International Criminal Court. What is the writ of habeas data? It is a remedy available to any person whose right to privacy in life, liberty, or security is violated or threatened by an unlawful act or omission of a public official or employees or of a private individual or entity engaged in gathering, collecting, or storing data or information regarding the person, family, home, and correspondence of the aggrieved party. Section 1, rule on the writ of habeas data. Now, the concept of native title, we have discussed that last time. So, let me just what is the Archipelago Doctrine? What are the two kinds of archipelagic states? To which kind is the Philippines classified? The coastal archipelagos and the outlying or mid-ocean archipelago. Now, coastal archipelago are those situated so close to the mainland that they may reasonably be considered part and parcel thereof, forming more or less an outer coastline from which the marginal sea is measured. So, marginal sea and the internal waters belong to the country. And then outlying or mid-ocean archipelagos group of islands situated out in the ocean at such a distance from the coast of firm land as to be considered an independent whole rather than forming part of the mainland. The Philippines is a mid-ocean archipelago. All right, going back to local government, does the city of Parañaque have the power to impose realty taxes on MIA? The answer is no, because it belongs to the government. It is titled to the government. Exception when it is leased out to a business enterprise, it becomes subject to realty tax. Then distinguish between a government-owned controlled corporation from an instrumentality of the government. We have discussed this last time, and government-owned and controlled corporation must be organized as a stock or non-stock corporation with capital stock divided into shares and authorized to distribute to the holders. If a stock corporation distribute dividends, now an instrumentality of the government is not a government-owned or controlled corporation, because a private corporation may be organized by the government based on two mandatory requirements. For public interest, it must be for public welfare, and number two, it must be economically viable so as not to waste public funds. Government-owned or controlled corporation may be created by Congress by special charters for the common good and economic viability. Now, the DAP and the PDAP, this has not been asked, and that is the constitutional provision on budgetary realignment. Now, only the President, the Supreme Court, and the members of the constitutional body have the right and authority to realign budget. Now, in the DAP and PDAP cases, budgetary realignment cannot have a cross-border realignment. In other words, the Senate President has the power of budgetary realignment. So has the Speaker of the House, but they cannot realign budget from savings to cross separation of powers in favor of the judiciary or the executive. The power of realignment may be exercised only within the same office, so under the office of the President. And Secretary Duque has no right to realign 42 billion, give it to Christopher Lau, for Christopher Lau to buy medical expenses, which is the function of the DOH Secretary Duque. Secretary Duque has no power of realignment, and what Lau said, that it is justified from the savings of the DOH, betrays gross ignorance of the law, because in the PDAP Napoles cases, the Supreme Court explained the meaning of realignment of savings. where the budget, rather, where the intended project has not been started, and the budget is realigned. That is illegal and unconstitutional. According to the Supreme Court, in the Napoles PDAP cases and the Noynoy Aquino DAP cases, realignment may be allowed from a particular project that has been completed and there are savings, and that savings might be realigned by the same by the same authority that is authorized to realign only from the savings. And so in the DAP cases, the Supreme Court held that where the project has not started, you cannot transfer funds to another purpose because realignment, budgetary realignment, under as allowed by the Constitution, is permitted only in case of savings. And savings mean that the project is completed and there are funds left that may be realigned. So I believe that Duque should resign. He should resign because he is guilty of gross negligence and violation of constitutional mandatory provision on handling of funds. And Christopher Lau should be prosecuted criminally based on his admission, because admission is the highest form of evidence. I remember when I was a young lawyer, a friend, a young lawyer, defended a case for the houseboy of an executive of Colgate, Palmolive. So the boy was, the houseboy was charged of stealing a can of biscuit worth 5 pesos, and he was prosecuted. And we tried the case. I was watching, and the witness pointed to the houseboy as the one who took the biscuit. Then the houseboy was put on the witness stand, and he was asked by a new graduate. And this was the question. There is a witness who testified that he saw you took the biscuit. What can you say about that? And the answer was, no, he was lying. There was nobody around when I took the biscuit. Admission is the highest form of evidence that requires no further corroboration. The new graduate lost the case because the client admitted to the theft of the biscuit. You may consider that as a joke or a figment of my wild imagination, but that is the case of Christopher Lau, who put a noose around his head. Can you imagine? 42 billion pesos on his own, accepted to be realigned, to do some function for Duque. And the most anomalous cut of all was that Duque was buying medical supplies from him, and naturally he must have put a little premium, because a dealer has to make some money on subsequent sale. But anyway, let me just continue. Now, here are the public funds not appropriated for a specific purpose may not be disbursed. The Philippines has the constitutional authority to realign and augment the budget from the savings from the budget in the projects allocated to the Office of the President for implementation of other projects under the Office of the President under Section 25, subparagraphs 5 and 6 of Article 6 of the 1987 Philippine Constitution, quoted as follows. No law shall be passed authorizing any transfer of appropriations. However, the President of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the heads of constitutional commissions may by law be authorized to augment any item in the General Appropriations Law for their respective offices from savings or other items of their respective appropriations. Discretionary funds appropriated for particular officials shall be disbursed only for public purposes to be supported by appropriate vouchers and subject to such guidelines as may be prescribed by law. Budget realignment or augmentation, whereby savings from a particular project may be realigned to another project in the same office, does not allow cross-border realignment to another branch of government under the doctrine of separation of powers. Public funds not appropriated for a specific purpose may not be disbursed. So the general absolute principle or the general principle is this: public funds may be disbursed only for public purposes as allocated by Congress or as appropriated by Congress. And public funds may not be disbursed to pay legal fees for private lawyers where there are lawyers in government who can render the same service. The only exception in the Pililla case is under the exigent emergency circumstances that there is no other lawyer available to represent a government entity, then engagement of a private lawyer by a government entity is justified, including payment of legal fees from public funds. But that is the narrow exception. And I believe that the payment in billion of pesos by the Central Bank of the Philippines in favor of a law firm is patently and grossly unconstitutional and a violation of the Anti-Graft and Corrupt Practices Act. And it is within the power of the COA to demand reimbursement of such illegal disbursements of public funds. It does not matter that the Bangko Sentral ng Pilipinas enjoys fiscal autonomy. Still, it is holding public funds and subject to accountabilities to the COA. The anomaly is that it is not being audited by the COA, although public funds are involved. We need reforms to improve the administration of justice. That's why I am posing questions to the aspirants for the presidency on their proposals and platforms. how to solve, number one, the problems of drugs, graft and corruption, not only in public office, specifically graft and corruption in the Supreme Court, and how to solve the 50 years old rebellion and insurrection being waged in the countryside by our Filipino brothers who are members of the NPA, and how to solve the terrorism in Mindanao, and how to unite and achieve everlasting peace and order in Mindanao. And more important of all, how and what are the programs of government to promote and accelerate economic growth and progress in the Philippines. And of course, as I have mentioned, peace and order. And also, what would be the stand on the South China Sea? Whether to continue adopting neutrality and amenity among nations, so that we can pursue independent public relations of amity and friendship with the United States, with China, and other countries of the world, to achieve cooperation in our region. And so, to my detractors, particularly my friend, I do not know if he considers me my friend, but I consider him my friend, Roger Castro, who was my classmate in the UP College of Law, that he was demonizing the administration out of personal hatred. And I made an appeal to him and to other detractors and those who do not agree with my opinions and personal beliefs. Let us agree to disagree with respect and sobriety, and let the people decide. You just campaign for your candidate, and let the people, the sovereign people, decide, because we are entitled to our respective opinion and to respect and sobriety. I am extending my arms for peace and cooperation, because everybody has in heart the betterment of the administration of government for our country. If I have not completed my discussion, I was supposed to discuss the Piyatko case. Let me see. The remaining issues, cybercrime, DAP-PDAP, citizenship, and then some more on martial law. Anyway, I think that in the course of my crossing and crisscrossing and assimilation and integration, I have covered mostly the important provisions, and anyway, I invite those who will take the bar to be patient and diligent enough to look up my legal forum on current issues in my Facebook. I have issued a number of them, including the prohibition under the Constitution for government officials to be financially interested in government transactions or on prohibited intervention. Just in the case of, as an example, Gordon, he voted for the passing of Bayanihan to Heal as One. There is a clause there granting emergency power for the purchase of medical supplies to address the COVID pandemic. Now, at the time the emergency purchases were made last year in March, on the early onset of the pandemic, the price was different because the supply was scarce and formally did not finance did not manufacture or finance the transaction. It merely acted as a broker, and we should be grateful that it was able to find the scarce supply at that time. Under the law of supply and demand, later on when there were abundant sources of supply, of course, the price would go down. But I am not advocating that we do not investigate. Let us investigate and let us find out, because the people are entitled to know what happened and who might be guilty of pocketing some public funds. That should be investigated, but not in the Senate, where the investigator like Gordon is has an ambition to become president, because due process requires an impartial investigator who cannot be the witness and the complainant rolled in one. That is the case rendered by the Supreme Court with respect to a case involving the PCGG, where the PCGG was the prosecutor, the witness providing the evidence, and at the same time the judge. In the case of Danding Kuwango, that was held to be unconstitutional because an investigator has to be impartial or neutral. So I wish we can have more time, but anyway, I think that would be enough for today. For next Saturday, I will prepare an overview of commercial law. The recent decisions, or the recent amendments to the Corporation Code, the General Banking Law, and then the Financial Insolvency and Rehabilitation Law, which is actually my forte. I am the only lawyer in Makati who is specializing in corporate rehabilitation, and that is actually our main practice with my children, even now in Makati, with so many business entities requiring suspension of payments because of the business reversals due to lockdown and discontinuance of the business. And I suppose that not so many questions have been asked in the bar, and this is very important because the PRIA has amended totally our old insolvency law. And commercial law really requires integration of various special laws to be able to answer properly questions in the bar, because a question in corporation law may require assimilation of the bulk sales law if what is involved is sales of all or substantially all of the assets, and what are the rights of the creditors, and what are the requirements under the bulk sales law and under the corporation law for sales of all or substantially all of the assets or business of a corporation may be declared valid. So until Saturday, and I will try as much as possible to comment on politics. We will consider on making those who are listening to me pass the November bar exam. So I hope that we can discuss commercial law on Saturday, all of commercial law. I can give you an overview of all the commercial law in 3 hours. I have been doing that, and I will do that for you. So thank you very much. Keep studying for those who will prepare for the bar, and keep safe, be healthy, because taking the bar is rigorous, and you need fresh physical condition to be able to answer properly problems in the bar. Sound mind in a sound body. Good luck to those who are taking the bar, and I encourage those who are hesitant to take the bar, because I believe that this is the best time and maybe the easiest bar exam, especially for those who have experience of work discipline, those who have been employed. They are better equipped with practical legal analysis to tackle the problems that might be asked by Justice Leonen in November, and hopefully there will be no more lockdown, and the conditions will improve so that we can have the bar and we can have the elections in May 2022. So good day, and thank you for listening to me. 12:45.